I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are jumping into number 78 of our compilation series. And if we had to give this one a name, I think you all agree that the name of this one would have to be Fez Fest, because this is going to be a compilation full of sovereign citizens that love to wear the Fez hat. Now, before I give you the rundown of the judges' courtrooms that we will be in on today, just know there will be no commentary at the end of this. Chapters will be added for your convenience. Don't forget to like, share, comment, subscribe. It is much appreciated. And listen, nothing else to do but to give you the rundown on these judges. The first judges' courtroom, and note, all of these, to no surprise, will be coming out of the state of Michigan. Now, the first judges' courtroom we will be in is Judge Aliyah Sabree. Second, we will be in the courtroom of Judge Sean Perkins. Third, we will be in the courtroom of Judge Adam Sabree. And last but not least, we will be in the courtroom of Judge Ronald Schafer. Listen, all of these proceedings are definitely classic ones from here on the channel and just on the internet, period. And listen, I know you guys are ready, and so am I. Let's go ahead and jump into number 78.
They're saying, well, hey, Mr. McCurry did this and did that. They come to my house. They bang on my door. They're impeding upon my freedoms, my sovereignty. They're a corporation. Corporations cannot act upon natural persons. Now, the case of Coins versus Virginia, 19 U.S. page 264, says that it started in D.C. They incorporated the inhabitants of D.C. and the states, other states. I am not a corporation. As I stated numerously in the beginning of this case, ab initio, I reserve my rights not to be compelled to perform under any contract or commercial agreement. I am a Moorish national sovereign. This court, as well as the people, have violated the Moroccan-American Treaty of Peace and Friendship of 28 June of 1786. Now, this quasi-contract that I presented to the courts, per the Michigan Supreme Court, the U.S. Supreme Court, this matter has already been litigated. And this court, as well as the people, are in default. And again, they refuse to give me their bond numbers, their names, and things of that nature, so that I may properly file a lien in the federal court, as well as I'm preparing a 42 U.S.C. 1983 case. Again, the state has no duty to protect private citizens from private citizens under the Cheney versus Winnebago Department of Social Services 489 U.S. 189 1989. If you go all the way back to the civil rights cases, the 13th and the 14th Amendments were created to protect African Americans from discrimination by city, county, and state and federal governments. And it also says in this case as well that they have no duty to protect private citizens from private citizens. So to compel performance of these corporate statutes, which it speaks about in Coins versus Virginia, again, 19 U.S. page 264, they created statutes to corporately punish the inhabitants of the city of Washington and the District of Columbia, and it went down into the other federal territories, as well as the cities, counties, and the state governments. And they're committing fraud against the people. These these statutes that they have me charged with are unconstitutional. And I ask even though you're in default, I'm giving the state another chance, but this right here is already locked in. They're in default because the law says where they have a legal or moral duty to respond, their silence is their acquiescence, their tacit agreement. So they're in default, Your Honor. And I would ask that the court subpoena Kim Worthy here so that we may put her on the stand to answer for her subordinates' criminal behavior as well as her criminal behavior. Have documents here where it's clear that they, can I sit down for a minute? My back is kind of bothering me. That's one thing to say. But I would like the Kim Worthy to be brought in so that she can be questioned about the change of venue, the allegations, which are factual. When they sent me to prison for 15 years and 8 months for no crime at all, Judge Kirsten Frank Kelly was in Wayne County. She issued an order against me that was null and void. I was railroaded, sent to prison, did 15 years and 8 months where I lost my mother. Family time away from my daughter, who's now 24 years old. She's a mother. I'm a grandfather. I've been productive in the community since I've been home. They're trying to make me look like I'm a demon. But the paperwork shows the opposite. And I would like all of these things. I would like an evidentiary hearing so that we may put these documents into evidence and that this case can be properly litigated, because the prosecution is committing crime. So I ask that this court use this subpoena power and adhere to their oath of Article 6, Section 2 of the U.S. Constitution, as well as Michigan Code of Judicial Conduct, Canon 2B. And the paperwork is clear. They refuse to respond. Everything that is happening now is criminal. In violation is conspiracy, 18 U.S.C. 241. And in violations, Michigan misconduct in office, MCL 750.505. I have been humble with this court. I haven't been here just trying not to disrupt the court. I'm under threat, duress, and coercion. You know what I'm saying? They have constantly been retaliating against the Detroit police as the sheriffs, as well as Kenworth's office. And it's well documented. They sent me to prison off the testimony of a perjured witness. And I would like all these things to be adjudicated properly in this matter. And jurisdiction has been challenged per federal and state case law. The people have to prove jurisdiction. They have statements. The corpus delicti rule bars statements as hearsay out of court. And this is what they're going is they cannot make an affidavit for anyone. You see what I'm saying? My brother, as they claim, made these statements. I still haven't been given any discovery or anything. And they're in violation of the Michigan court case law, Court of Appeals case law, and People versus Davey. This court clearly twice told me to give them discovery, 225 Michigan Appeal 502. And they're still violating the court's orders. And this court, honorable court, should exercise the contempt powers and have these officers supposedly acting for the court, which are being criminal, to be put in jail until they comply and or fined. Detroit police has a history. They were prosecuted by the Department of Justice in 2001. Then they were under the consent decree into 2013. And they're still committing atrocious criminal behavior and acts against natural persons, natural citizens. You know, Judge, you're familiar with this case law. You're a licensed attorney and an elected or appointed judge. I don't know. But the Supreme Court under Marbury versus Madison rulings, they're decisive, let the decision stand. This court is bound to adhere to Supreme Court rulings. These statutes in which they're charging me with are unconstitutional in violation of the civil rights cases, as well as Cohen's versus Virginia, the Supreme Court. And today, again, I respectfully compel this court to adhere to these things. And the Supreme Court says where a court does not have jurisdiction to act, or where they don't have jurisdiction to refuse to act, it's considered treason against the U.S. Constitution, Ron. And the paperwork is clear. All parties that I've served these papers on are in default, Your Honor. And I ask that this court, like on page 13 and 14, I clearly stated in the offer, I'm the offerer, they're the offerees. And this process is approved by the Michigan Court of Appeals, Michigan Supreme Court, in which they cite federal court case law and the federal court cases, cite these cases as well. Give me a second, please. On page 13, it says, offerees 1 and 2 agree that all above and below statements are true, and they have until May 24, 2023 to admit or deny the above, and agree that terms, A, failure to hold state laws unconstitutional, and void ab initio, agrees to give me in the sum of $5,000 in gold and silver coins and or Federal Reserve notes and assets in their personal and official capacity. B, failure to dismiss charges with prejudice and grant all of the above, all of the supra and infra, agreed to give me $500,000 and agreed to be charged via MCL 750, 505, 18 USC 241, 18 USC 242 by the U.S. attorney and the state's attorney for their crimes via Turner Associates Inc. versus Small Parks Inc. 59 Federal subsection 674 at page 680 through 82. Eastern District of Michigan, 1999, where they have a legal and moral duty to speak and agree that if they, offerees 1 and 2, try to impair this quasi contract, argue or try to litigate this case further, Instead of dismissal with prejudice, agreed to give me $1 million in their individual capacity via Holland versus Earl Graves, Publishing Code 46, Federal Subsecond 681 at 685 through 687, Eastern District of Michigan. Then there's affidavit of truth. I, Cornell M. McQuarrie Eel, says that the above is true and correct, and email these pleadings to offerees 1 and 2, which is Ken Worthy, as well as this court on May 10th of 2023, and I signed it. The law is clear, Judge, and this court must enforce the law as written by the higher courts. This court is an administrative district court acting on a corporate level, and they cannot conflict, basically issue their rulings in conflict with federal Supreme Court ruling, which they have taken an oath to do so. If this honorable court refused to do so, it would be treason against the U.S. Constitution. And I ask that this case be dismissed at this juncture because statements, I have not been given anything by the prosecution and the people. And I would also ask that this court exercise the subpoena power and have Kim Worthy come here. She's not God. She's not a queen. She's not an empress or anything. She's an elected official. And her history precedes herself as committing crimes against citizens like Devontae Safford, Daryl Siggers, all these people that they're saying that they're trying to help get out of prison under the wrongful convictions unit. Valerie R. Newman was my former attorney, and that also makes it a conflict of interest because Judge Kirsten Kelly heard her on appeal. She let the judge do it, and I had to do almost 16 years in prison for a crime where there was no legal jurisdiction at all. And there's documented evidence, paperwork, court seal, signature, and I'm being criminally retaliated against by the people. There's no way they can wiggle their way out of this. And I would like these things to be adjudicated and evidence. I would like an evidentiary hearing so we can admit evidence and or suppress evidence. I haven't been given discovery. I didn't even know I had court the first time I came. I had to go online and look it up. These are the games that they're playing. And I would like their oaths of office, their bonds, as well as other things. Because they're committing felonies, Your Honor. All due respect, and like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child. And the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may. Like the great honorable Judge Dalton A. Robinson, when he was in office many years ago, he did the right thing. They tried to get him to send these young juveniles to prison. He said, no, these young men can be rehabilitated. And he sent them to juvenile prison. At this time, the prosecutor then went and attacked this judge. You see what I'm saying? You have a right and a duty to fulfill your constitutional oath, Your Honor, regardless of what they think about you or whatever else. These these statutes in which they're charging me with are unconstitutional. I never signed any agreements with the cities, counties, states, or whatever else to be governed by them, to adhere to their statutorily corporate statutes, which in Coins versus Virginia clearly states this is what the system is about. To create penitentiaries, to create prisons, hospitals, graveyards, streetlights, so on and so forth, in which today we live in this society. This society is clearly the matrix. The legal system is unconstitutional. These are corporate enterprises. They're no different than any other corporate enterprise when they provide services for the citizens. The case law clearly breaks it all down. I've never surrendered my sovereignty. Dred Scott versus Sanford clearly stated that blacks could not be citizens, were never intended to be citizens, and we were 3/4 of human beings. But under the democracy, pardon, 3/5, okay, 3/5. Under the democracy, which is nothing but the mob rule of the old South and European inhabitants of this country, if someone killed someone, stole something, they were all the mob who go out there and hang them and do whatever else. So every government is entitled to a Republican form of government, not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default.
Lamont Harrison Lemon, the second.
Both of the devices in here for that, because I believe there were 2 devices.
That's the gentleman with the Fez hat on, headgear on. Can you unmute yourself, please, sir? Is he connected to audio?
It appears to be.
Lemon Bay, Harrison Lemon Bay. Can you hear me, sir?
Can you hear me?
I can hear you. Good morning to you.
How are you?
Okay. Are you the second or the third?
I'm here on behalf of the third.
The third. Okay. And I guess it's the second as well. This is the city of Detroit versus Harrison Lemon Bay the third. Straight that. This is the state of Michigan versus Harrison Lemon Bay the third. Case number SX 419-5968. Counts 1 and counts 3. Appearance for the record, please.
Howard S. Berry Jr. on behalf of the defendant. State your full name, sir.
Your Honor,
Mr. Berry, I think he's representing himself.
Your Honor,
Yeah. Yeah. All right. And add count 3 to that. Add count 3 to that record as well. Or count 2 to that, or 1 to that record as well. So count 1, 2, and 3. Let me have that other. I believe, state your name for the record, Mr. Lemon the third.
Yes, I am Harrison Lemon Bay, all lowercase letters. And I'm here on behalf of Harrison Lemon the third.
All right. Well, I've never heard of the all lowercase letters. What does that mean?
It means that the name is to be spelled with all lowercase letters, not all capital letters, not part capital and lowercase, strictly all lowercase.
All right. So today is the date and time set for a pretrial in the matter. How do you want to proceed, sir? I know you filed some documents with the court, and I did have those up in my chambers. But how do you want to proceed?
Your Honor, I'm the surety on behalf of the principal debtor, strawman Harrison Lemon III. I've given the court notice weeks in advance. I'm here to tender a special deposit to the court and make the clerk fiduciary, the prosecutor, as well. And I'm looking for a plea of release today. Will you grant a plea to release?
No. I can grant you a pretrial. I can grant you the opportunity to speak with the city attorney, or I can grant you a trial date by judge or by jury.
Yeah. So
what would you like to do, Mr. Lemon Bay?
Well, do you mind if I ask a couple of questions? Just want to make sure that I'm comprehending it.
You may.
All right. So as you gave the name, I heard you mention a few different names. I heard you mention Harrison Lemon Bay the third, and then a Harrison Lamont the second, and various different names. I just want to make sure that I'm clear on who or what it is that we're here to discuss, because I don't want to speak on behalf of.
It does have an error. It does have an error. It appears to be an error on the computer here. So entry date, one of the counts was entered into as one count was entered into as Harris Lemon III. The other count was Harris Lemon II, and the other count was entered Harris III Lemon. So I think that's just a typo. There's the nature of the offenses is the misdemeanor case is driving without a valid operator's license, no ops on person, and that is a 93-day punishable by the maximum possible penalty, 93 days in jail and or $500 in fines. And you have two civil infractions, one expired plates, and the other one speeding at 16 to 20 miles an hour over the speed limit. So those are the nature of the charges. I'm going to offer you an opportunity to mitigate this by taking the better driver's course, sir. I'm going to put that in the chat if you choose to. And I can give you time to do that. If not, you can set it for a trial date or whatever set it for a trial date or speak with the city attorney today. What would you like to do?
I'm really, again, I'm ultimately I'm here to tender special deposit and settle the charges. You know, make the clerk fiduciary.
Well, you settle it by pleading to in taking a plea today, paying the fines, or taking it to trial. See if you can do better at trial. You have a right to a trial by judge or jury, and that's it. Those are your only options, sir.
I'm looking for a plea release. Are you stating that there's no offer of equity in this matter, Your Honor?
I don't know what you're talking about. All right, we're gonna move on. So I don't have time for this.
Would you like to speak to an attorney? Would you like to speak to an attorney, sir?
I don't. I'm not asking for counsel.
Okay. Well, we're gonna pass the matter and we're gonna move on, and he can just watch and see how it works in here, because I have too many people that are waiting that want to be heard and hear their claim, and I don't understand what you're saying. I've given you your options, and you can sit back and ponder those. I'll give you time to ponder those options. Other than that, sir, I don't know what else to tell you. All right, let's move on. Next time. No, I've already answered the questions I'm going to answer. No, please mute your device, and you either take the offers that I've given you, speak with the attorney, or take the deal, or set the matter for a trial date. Those are your options.
Let me set the matter for trial.
Set the matter for trial. Okay, I'm going to give you a trial. I'm going to give you, do you want trial by judge or jury, sir?
Your Honor, by jury.
Okay, jury trial. Can I get a jury trial date, please? Soonest one you have.
We set one on the 29th. Is that right?
No, yeah. Let's set the earliest one you have.
June 5th. Well, we are June the 2nd.
June the 2nd?
Let me see. Yeah. No.
All right, June the 2nd.
Or we have 15th, we have one, right? And the next one will be July the 13th. Because we have one on the 15th. And I think
Let's do June the 2nd. June the 2nd. We should do this in the afternoon as well.
Well, we gotta set a pre-trial first.
Yeah, we'll set a pretrial. We'll set a, so your next court date is gonna be a final pretrial, sir? Final pretrial will be June the 1st, 6/1/2023 at 8:30. If you, and then we'll set the jury trial date for the next day. We'll set it at 2:30. All right, we'll have you at 9:30 on June the 2nd. So your next action date that you need to appear is June the 1st at 8:30, and then the next day we'll have the jury trial at June the 2nd, 2023. I have received your motions. If you have any more motions, make sure they're in before the June the 1st date, and then we'll proceed with picking a jury, setting a jury panel at 9:30 on June the 2nd. If you don't have any further questions, Mr. Lemon Bay, then have a very good day, sir, all right? Good luck to you.
Best of luck to you.
Thank you.
Hello, this is Mr. Raleigh. I'm here on the matter. I couldn't hear.
All right, Mr. Raleigh, thank you for, that was gonna be my suggestion, to log out and log back in, but you did use the chat.
I am here on that matter, my honor. I am, for the record, on the record, and let the record show I am not a 13th Amendment free Negro slave, nor chattel, nor 14th Amendment United States corporate citizen. I am a national, I am a Moorish American, and I have standing ancestral estate, Moroccan Empire, the adjoining islands by inheritance, but not by purchase, Moorish pedigree. I am competent, I am allodial, and I'm liberated. I am all rights preserved and retained without prejudice or recourse. Certificate registration number AA 77869, March 25th, 1848 AD, corresponding to the Moorish calendar 1368. Copyright owner C.M. Bays. Clock of Destiny, March 25th, 48 AD. MC 1368. Certificate registration number AA 209316, March 31st, 1952 AD. MC 1327. Masonry plus art, astrology, history, and geography. Clock of Destiny 2, reused edition of the previous book of Clock of Destiny, Title 22, Chapter 2, Council Courts General Information. Certificate registration number AA 222141, September 8th, 1952. AD MC 1372, Clock of Destiny, Moorish American, all Moroccan nationality card or identification with Zodiac Constitution, and certificate AA 222141 is the focus of the determination for the without a doubt affirming relationship of the relationship properly venue as law between the Moorish Franks and all foreign Christian nations. Title 8, United States Code 1324, federally protected Moors.
What did you say about the Christian nations? What you just said about, this only applies to the Christian nations?
It says other foreign Christian nations.
Other foreign Christian nation. What is a Christian nation?
What is a Christian nation? Well, that I would not know because I am a Moorish American. I'm more into being related to Moorish American ideology.
I was just trying to figure out, I was just listening. I was listening in. All right. Okay. Well, I have you checked in, Mr. Riley.
Okay.
And Ms. Haddad, are you requesting legal counsel?
No.
Okay. Ms. Haddad will be with you shortly. She has the rest of the cases on the docket. So when she's done, it looks like she's in the breakout room with Terry Yancey. When she's done with Terry Yancey, she'll have the opportunity to talk to you. And then I can call your case eventually.
All right.
Yeah. All right, so just sit tight and we'll get to you shortly. Thank you.
All right.
Take care.
All right.
Mr. Raley, can you join the breakout room? I have sent you an invitation.
Breakout room.
I'll send you another invite. Give me 1 sec. Do you see the invite, Mr. Raley? We are ready on the case ending in 509, Your Honor.
$509.
Yes, Judge.
Calling case number 2334559. This is Harriet Tubman Apartments versus Brian Riley and all occupants.
Good afternoon, Your Honor. For the record, Rania Haddad, P84927 on behalf of the plaintiff.
And Mr. Riley, can you please just state your name? Let's see, I want to prompt you to.
A minute. Okay. For the record, my name is Brian D. Raleigh. Hello?
All right. Yes, yes, sir. Thank you. All right, were parties able to work out some type of resolution?
Yes, Your Honor. The parties have agreed to enter into a conditional dismissal with box 4B checked. Mr. Raley's balance due and owing is $2,088.46. He will pay he's going to pay $742 on the 5th of every month, beginning on 5/5. That $742 includes his $542 of monthly rent per month, and then an additional $200 towards the balance. So he will pay on the 5th of every month, starting on May 5th, 2023, $742 until the balance reaches zero. And then after the balance is zero, he will resume his regular monthly rent.
And the regular monthly rent is $542, correct?
Correct, Your Honor.
So $200 extra. Is it 2088.44?
It is 2088.46.
24/6, okay. All right. And is 4B checked?
Yes, Your Honor.
All right, Mr. Riley, do you understand the terms of this agreement?
Yes, I do.
All right, if you make those payments, your matter will be dismissed. In the event you don't, a judgment and a writ of eviction can be filed at the same time. We wouldn't have to come back to court. So, good luck. Wish you well. Have a great day. Do you have any questions?
No, my honor.
All right. Well, thank you.
Thank you, Judge.
You are welcome. Take care, Mr. Riley.
All right. You too.
All right. Thank
you. Oh, one answer. Okay. What the?
Hey, can you call up Newton Hensley Bay?
Mr. Bay, why are you not here today?
The schools and everything are closed today, so I ain't have no babysitters or anything at the last moment.
All right. Well, you do have some motions and you also have a sentencing date, but I need you in person for this today. All right. You gonna be able to get over here later this morning?
I'll try to be on my route right now, Islam.
We call the case of People v. Milton Hensley Jr. This is case number 23S18766FH. The defendant is present in person.
Object. Compilation is Milton Hensley Bay.
So two things here that are odd. Go. So this bond, so today it looks like we just have his motions today. We don't have a sentencing. So we don't have a PSI completed then.
Correct. I'm still waiting for the referral from the prosecutor's office, so I don't even have a date yet, but he did come to the office.
Okay. All right. So Mr. Hensley, then I thought we had a sentencing date today. So it's just your motion today. So just like I have every time you're here, I got to go through these questions with you. All right. And I want to make sure we cover them. Yeah, go ahead.
My honor, my name is Milton Hensley Bay.
I try to remember that, Hensley Bay. All right, go ahead.
And I come before this honorable court today to respectfully address a matter of significant importance related to the case at hand. I hope to present this statement with clarity and transparency. On the 8th of January 2024, my honor rendered a judgment following the trial proceeding in this matter. Subsequent to the judgment, I, Milton Hensley Bay, filed an appeal with the Michigan Court of Appeals. The appeal has been accepted and is bears a claim of appeal number 369382. I am compelled to inform this court that I am impelled to inform this court that in the light of ongoing appeal process, I find it necessary to request a stay of the proceeding in this court. The decision of the Michigan Court of Appeal will likely have a profound impact on the direction and resolution of this case. Furthermore, Your Honor, I must express that during the trial, my request for a continuance was denied, hindering my ability to adequately prepare for the proceeding. Thus, compiled with my current indigent status, present substantial challenges, I am unable to afford the costs associated with obtaining additional transcripts, filing experiences, and even basic living costs as I navigate through this appellate process. In consideration of my indigent status, I respectfully request that the court waive the bond option or any bond requirement in this case. The financial constraints I face make it impractical for me to meet the financial obligation associated with posting a bond. Waiving the bond requirement would ensure that I can effectively participate in the ongoing legal process despite my financial limitation. I humbly move to this court to enter in order to stay the proceeding in consideration of the pending appeal with the Michigan Court of Appeals. My Honor, I understand and comprehend the gravity of this request and assure that the courtroom that it is made in the interest of justice and the fair adjudication of my case. I am grateful for the court's attention to this matter, and I am prepared to provide any additional information or clarification deemed necessary by the court without self-incrimination. Thank you for your consideration. Your Honor, respectfully, Milton Hensley Bay.
All right, so Mr. Hensley, I do have to ask these questions again, so they're gonna sound familiar to you. So you've got this motion before the court scheduled today. You do understand that you have a right to have the assistance of an attorney at any stage of the proceedings. This is another stage of the proceedings. Sir, are you waiving your right to have an attorney? You continue to want to represent yourself, or would you like the court to appoint an attorney?
Continue to represent myself.
Very good. And then you understand that if you can't afford a lawyer, the court could appoint one for you. Would you like the court to do that?
No.
Okay. You understand that the charges that have been brought against you and now that you've been convicted of, those are serious charges. They, again, are the charges of, let me pull the information here. All right, count one is carrying a concealed weapon. That's a 5-year felony and or a $2,500 fine with mandatory forfeiture of the weapon or device. Count two is assault with a dangerous weapon. That's commonly known as felonious assault. That's a 4-year felony and or a $2,000 fine. A consecutive sentence can be imposed if the assault was committed in a place of confinement. And finally, count three is felony firearm, which is a 2-year felony. However, it's 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, along with mandatory weapon forfeiture of the weapon or device. So again, do you understand the nature of those charges and the maximum penalties, sir?
I comprehend.
All right. And as it relates to count three, that's worth some, I guess, a special acknowledgement. We've talked about this previously, but that charge by itself requires the court to sentence you to 2 years in prison, which you would have to serve before you would begin to serve any sentence on counts 1 and 2. Do you understand that?
Comprehend.
And knowing that, you still wish to go forward representing yourself?
I represent myself. Yes.
Very good, sir. Do you understand that there's risk of representing yourself?
I do not understand.
You understand that there's risk of representing yourself because the other side is represented by attorneys, and the court will be required, as I have throughout the proceedings, to hold you to the same standard as an attorney, and the court couldn't give you any special consideration or assistance, if you will, with your motions or defense or anything of that nature. In other words, I have to treat you the very same that I would the other side, and they're represented by attorney. Do you understand that?
Well, Hernan versus Kane said you can't treat me as a jurist because I'm not one.
All right, so we did go through that. You did raise that motion earlier. Court has a different interpretation of that case and what it meant as it relates to pleadings and not actual motions or trials. But do you understand, though, that you could be at a risk of by representing yourself, and that you are not going to have the training, the experience, or the education that the other side does?
I comprehend. I comprehend.
Okay. Do you understand that I have to require you to follow all the rules and the same requirements that apply to lawyers in this courtroom? You understand that?
I don't understand that.
Okay, so I just went through this. Do you want to represent yourself? The court has to treat you the same as the attorneys. I can't give you any special help or relax rules or something like that simply because you're representing yourself. Do you understand?
I comprehend.
Very good. That's a long way of the court saying I can't give you any special treatment if you want to represent yourself. Do you understand that? Okay. Would you like the opportunity to either hire an attorney or just talk to a court-appointed attorney before we keep proceeding today?
No, we're not.
And then do you agree if we go forward with your motion today that you'll follow all the same rules that the attorneys and anybody else appearing in this courtroom are going to be subject to. Okay. Mr. Butler, do you have any questions regarding his waiver to counsel?
Thank you.
All right, you believe the court's complied with MCR 6.005?
I do.
All right. So as far as the court is concerned, Mr. Hensley Bay has represented himself from day one in this case. The court has tried to run through all of the questions that have been provided by SCAO to trial courts as sort of guidance, if you will, for those representing themselves and wishing to represent themselves. Mr. Hensley Bay has been consistent in his desire, his right, if you will, to represent himself. I find that remains the case today. Again, the court asking these same questions multiple times of him. And when we do this, I don't mean to insult Mr. Hensley Bay's intelligence. It's just something the court is required to do. And it might, from his perspective, seem like, why do you keep asking me these same questions? I want to represent myself. I have a right to do that. And you're correct, but we do need to do this each time, at least this court's interpretation, each time that you appear, because you certainly have a right to change your mind too. You want to hire an attorney or ask for court-appointed attorney, we can do that also, and then delay the proceeding until you retain or have a court-appointed counsel appointed. All right, so I do find that your waiver today, again, is knowing, intelligently, and voluntarily made. I would characterize it as unequivocal. Again, Mr. Hensley Bay has been steadfast in his desire to represent himself. I believe the court has, and Mr. Hensley Bay has also acknowledged the dangers of self-representation, that he'd be held, in essence, to the same standard as anybody else, court rules, rules of evidence, those types of things. And therefore, the court will then allow Mr. Hensley Bay then to proceed today. He has a motion before the court to stay the proceedings pending appellate decision. Now, this is one of those things, again, comes up when folks in representing themselves. He has filed his motion, scheduled it on for today, it appears. But he's also filed a claim of appeal. At least in this court's opinion, that claim of appeal is premature and that Mr. Hensley Bay simply has not been sentenced yet. So to the extent the court has one here in front of me, a claim of appeal that appears to bear his signature and was dated January 16th, it's not something the court would consider or can consider, at least in the court's opinion, because he's not yet been sentenced. Now, this is something he certainly can file post-sentencing, but that leaves us then today to the motion that was filed, which is simply a motion to stay the trial court proceedings. Mr. Hensley Bay, is there anything you want to state this morning in support of your motion to stay the proceedings, which would mean, in essence, the sentencing date that is, I don't know that we have a date yet, do we?
No.
That will occur at some point in the future.
Only thing I have to add, Young, is what I just read to you.
Okay.
A motion to stay, granted that everything been done, cases over with the Court of Appeals. They gave me a number and everything, so the case is active. And I just ask that you, give me a motion to stay where we can get everything in order, because I also paid for the transcripts, and I was told it would take maybe 3 months before I can get them. So I just rush to the court to give me that time, render that time to get these things in order.
All right, then Mr. Butler, what's the people's position on Mr. Hensley Bay's motion to stay?
So, Your Honor, I did receive a motion, I suppose, from the defendant. It looks like sometime in maybe January. And it's titled motion to stay court proceedings pending appellate decision. And it is 3 pages. Last night, I received an email about 7:25 p.m. from someone other than the defendant, Curtis Sean Joseph Bay, sending an email, it appears on behalf of the defendant, with an amended motion for stay of execution pending appeal. Did that get filed with the court?
I've not seen it, no.
Okay. So I suppose I won't address that then. Just looking at what
it was filed on the 22nd.
So, Mr. Hensley, that raises a different question I'm concerned about. So you've consistently represented that you want to represent yourself. This would sound like this is a third individual that's filing something on your behalf.
No.
Is that correct?
Yes.
Okay. Who's the third individual?
You told this Curtis Bay.
Curtis what?
Bay. Sean Bay. Yes.
Curtis Bay. So is that a relative of yours or something?
Yes.
Okay. Is he an attorney?
He have information.
All right, but he's not an attorney.
That's my knowledge. No.
All right. So because it's not been filed with the court, certainly Mr. Butler has raised it. Court would not consider that today.
No, it's been filed. It was filed on the 22nd.
I don't have that. We'll have it. Hold on. We'll have Mr. Geiger, our clerk, is going to search for that. But even if it was filed on your behalf, if it's not an attorney and you've indicated to the court you want to represent yourself, courts can't consider that anyway. All right. Because a non-attorney cannot represent you. You can represent yourself, or you can have an attorney represent you, but you can't have a non-attorney that's represent.
According to my nationality, Moorish American, we have counsel. And that's how we do with counsel.
Yeah. Well, I'm not aware of a court rule that would allow the court to have a non-attorney practice law. So that's a bridge we can cross, I guess, if and when we get it. But then, Mr. Butler, I would like you to address Mr. Hensley Bay's motion to stay the proceeding.
Thank you. Then just focusing then on the January 10th motion that was filed. The defendant doesn't give any rational basis for the stay of proceedings. There's no citations. There's nothing, no court rule or case law, nothing like that cited. What the defendant does cite is Rule 6.004 in regard to speedy trials, which is wholly applicable to this case altogether. The defendant is not in custody. He's not an inmate, a prison inmate. It just does not apply. And so with that, we would ask Your Honor to deny the defendant's motion based on lack of merit.
All right, Mr. Hensley Bay, I am going to deny the motion for stay. Mr. Butler's correct in reviewing what you have filed here, and it's a 3-page document. The third page is just a signature page. It looks like there is no grounds that has been cited that the court could rely on that would make sense for a stay. Now, you certainly still have a right, I'm going to deny that, but you certainly still have a right. You can file a request to stay the proceedings in the circuit, in the appellate courts. There is a mechanism to do that where you could then also ask for an expedited review of the same. But I don't know that I'm aware of that, other than you're indicating you have, and you have filed this thing called claim of appeal, which again, this court does not believe is appropriate because you've not yet been sentenced. In essence, I think what you want to do is you want to have a adjournment of this, or stay of the proceedings, if you will, to have the court review something that is not yet right, which is the outcome of your trial. And it's not yet right because you've not yet been sentenced. So I'm going to deny that motion. I'm going to ask Mr. Butler to prepare an order that says your motion to stay the proceeding is denied. Now, if you do file something with the Court of Appeals and they grant your request for a stay, they would inform the trial court that the proceedings have been stayed.
Can I get that?
And then we would go from there. What's that? All right, so just for the record, so the clerk has just handed to the court a filing that occurred yesterday. It is titled Amended Motion for Stay of Execution Pending Appeal Bond to be Waived. It's 1, 2, 3 pages in length. That is filed by Milton Hensley Bay, and that appears to be were these other pages attached? Exhibit for a motion to stay.
I believe there.
Okay, so then there's a third page that says exhibit for a motion to stay, case information, case header, case number, Court of Appeals 369382. Second page is citing looks like the parties, Allegheny County prosecutor, and then Hensley, Milton, Joseph. 11604, it's or 24, incomplete filing, order appealed from trial court on the circuit court, and then my name is a trial judge. Motion waived, transcript was requested, defective holding file letter. All right, so that looks like, I guess it could be, it's a copy. This was filed with the clerk's office, maybe what Mr. Hensley Bay has been referring to. He had something up a moment ago. So it looks like maybe he did file something with the Court of Appeals. So if you did, sir, this court certainly will take direction from the Court of Appeals if they give us some sort of indication that they have stayed these proceedings, or they will give you additional direction along with the court, what they are looking at as it relates to this filing, whether they have accepted it, rejected it as being incomplete, or something of those.
Well, they say they accepted it when they give me the number. That number you just read out there,
yeah.
369.
Yeah.
382. That was the number that they when they give it to me,
right.
the number they accepted.
Yeah.
So that's why I came when they gave me the information. That's why I presented the information to y'all yesterday. When it was also presented to me.
So that's been filed with the clerk's office, but it doesn't change this court's opinion about the motion that was properly before the court today, which was a motion to stay the proceedings. I'm going to deny that. I'm going to ask the prosecutor to prepare an order that indicates so I can sign it, and then you certainly can get a copy of it from the clerk's office so that we're all on the same page. Now, again, if this, meaning this filing that I was just handed, results in some sort of direction from the Court of Appeals that your case has stayed, meaning the sentencing date, that we're going to stay the proceedings and the only thing left would be a sentencing date, then certainly the court would follow that directive. But right now, I'm denying your motion to stay the proceedings. And then, Ms. Bond, can you give us an update then? I have Mr. Hensley Bay here. What's the status of that PSI?
I have yet to receive the referral from the prosecutor's office, so we haven't even begun the process yet.
Oh. So I assume he checked in with you though after his trial date?
Yes,
okay.
He did come following the trial and completed his packet. So
all
I
right.
do have all that.
So you'll be contacting him in the future to then complete a
yes,
PSI?
Correct, yep.
All right. Then, Mr. Butler, you'll prepare the order denying his motion here today.
Yes.
All right. Then, Mr. Hensley Bay, that just means that we'll stay on track for a sentencing date. I can't tell you when that will be yet. They're going to contact me, probation will contact you to begin, or I guess not to begin, to continue is the way I would put it, that process of completing the pre-sentence report. As I mentioned to you before, once that's completed, then you'll get a copy of it. You'll have a chance to check it for accuracy so you can let the court know when we come back for sentencing if there's any information in the report that is inaccurate, then we can get those corrections made so we have accurate information on which to base sentencing.
Can you also give me a ruling on, because I also asked the court, because of my financial situation, can you waive some of the transcript fees and the filing fees?
So it was my understanding that the court already signed a waiver, didn't they? I thought you were given a waiver. Yes?
For court filings.
Oh, for court filings. Okay, for transcripts. So maybe that was in here. I thought. Let's look at that.
I think Selena was holding on to it.
Who was?
Selena.
Oh, well, maybe she has it. We
Great.
can talk about it now. Oh, here. Let's see. All right. So this looks like this was filed on January 10th. All right. So the court does have it. So Mr. Hensley Bay, you did file a fee waiver request. You indicate you receive SSI, and you didn't fill out any additional information as it relates to income. So there's a box 3, your household income, the number of people in your household, your source of income. The court did review this on the 11th. It looks like at that time, the court denied it because I didn't have all the information, income information had not been provided. So if you want to complete this, I certainly would review it again today. So it's that box Bree, if you want to approach. Thank you. All right, thank you, sir. So for the record, Mr. Hensley Bay has returned this to the court. So we have a gross income of $1,900. Is that every week or every 2 weeks or a month?
No, that's once a month.
Once a month, all right. And the source of the income is the SSI.
SSDI.
Mr. Hensley Bay, it's curious to the court. When I'm looking at my notes from the trial, you indicate you're on this supplemental income, Social Security, if you will. I guess not supplemental, Social Security. But the testimony from both the 404B witness from the prior incident you had in Grand Rapids and then this incident, if I recall, you were driving a newer BMW. You might have been driving a Mercedes with the incident in.
And it was my vehicle.
Grand Rapids. Whose vehicle was
that? For Sarah.
What's that?
The BMW is for Sarah.
Okay. Did you have a different sort of income back then? No.
The Range Rover, the Range Rover was 2011. Automatic vehicle. Somebody I knew, somebody I was affiliated with, kind of helped me.
Okay. And then the other thing that's troubling to the court, as I'm handed this and you've finished filling it out, I think my administrator indicated you came in and paid cash for your transcript already. Is that accurate?
Yes.
Okay. So is the cash part of your $1,900 a month?
Yeah, man, I'm depleted. That's man, I'm 50 years old, so everything I had saved, man, that's what it was.
All right. So here's, I guess, my question. I don't know this. Do you know, was that the amount that was provided by Mr. Hensley Bay? Is that the full amount of his transcript, or is
Estimated full amount.
That's estimated full amount.
Mhm.
All right. Well, here's the issue with that, Mr. Hensley Bay. My understanding of the court rule is the fact that you are receiving Social Security makes you eligible for a waiver. So I'm going to sign your waiver. I'm going to redate it today. I'm going to check the appropriate box, cross these out. Just got to note Social Security. It would be the 23rd, 2024. And then I'm going to check cash to be returned. Now, if you want to use that to hire an attorney for your sentencing date, you're welcome to do that. You're welcome to continue to represent yourself. Do you have any questions about anything?
Just gratitude.
All right, so I'm going to give this to my court staff, and I'm going to ask you to step over to the clerk's office, or not, to the circuit court office, which is right outside this door. You can talk to my administrator. What I'd like you to do is I'm going to have her drop a piece of paper. You both can stand there and count the cash, and then you'll acknowledge that I don't know what the amount was, but whatever you gave to the court is being returned to you. I'd ask that you sign and acknowledge that. All right.
Okay. Gratitude.
Okay. They're going to contact you, meaning probation, to finish the PSI, and then once that's done, we'll give you a new sentencing date. Okay. I apologize. I thought this was the sentencing date. You do need to be in person for the sentencing date. If this was just a motion, I certainly, and had I known that, I would have let you appear remotely. But I thought you were here for sentencing. All right. So I know that you appear for your court date, so I'm not concerned about that. Mr. Butler, anything else?
No.
Okay, you're all set today, Mr. Anthony.
Sure.
You have a order for me? To deny the motion?
All right.
No, I don't, I'll see the printed, prepared.
I'm gonna wait for it, I'm gonna bring it to the federal court.
Okay, yeah, that's fine.
All right, and then we're going to continue with our docket. So you're all set today. You're free to wait. Mr. Butler.
I'm not threatening you. Say one more word and that's 30 days. 30 days.